In this lesson, we're going to carry on talking about the constitution of a company, focusing specifically in this video on the nature of corporate capacity. So, essentially, corporate capacity in English law refers to a company's ability to enter into legal transactions, contracts, and obligations. And this is a very important process that takes place, and it's a process that is often defined by their memorandum of association or their articles of association, hence why we have got this particular topic on this particular chapter here. And so really you have to think about this in relation to what we also discussed in the previous set of videos, the previous chapter on the nature of corporate personality. Remember, we know that when you create a company, when you go through the process of incorporation, what you're essentially doing is creating a new legal person. We're creating a person who has personhood, okay? Not in the sense that they are a physical person like you and I, but in the sense that they have personhood in law. They are their own entity that is separate from the people that create it. That's where we get limited liability. That's where we get the corporate veil. That's where we get the circumstances in which the corporate veil may or may not be lifted or pierced. And one of the reasons why this is important is not only because of liability when it comes to insolvency and the fact that a company director and shareholders, when operating a limited liability, want to do so because they want to be able to take risks in business without feeling that they are going to have to incur the costs of the debts for those risks themselves. And that's why the limited liability is so powerful, because it allows for risks to be taken in business. Sometimes those firms will then be wound up and go into insolvency and be wound up, or enter into administration or whatever. But in other cases, they will be successful and there will be good returns on those investments as a result. So that's one of the reasons why the nature of corporate personality is so important. But another reason is because we're talking about a separate entity in law, a separate legal person. That separate legal person should have the ability, or should I say the corporate capacity, to enter into transactions, to sign contracts or to create contracts, or to have obligations in a similar way that you would in an ordinary sense of legal transactions yourself. And so that's what the idea of corporate capacity means and why we're talking about it here. The concept determines the scope of activities that a company can lawfully engage in. Historically, corporate capacity is heavily restricted by something known as the ultra vires doctrine. So for those of you who do not know, who haven't studied constitutional law or haven't studied public law, the ultra vires doctrine is similar in company law as it is in the law of the UK Constitution, in the sense that ultra vires refers to acting beyond one's authority. And so public authorities, when we talk about administrative law, can be found in a judicial review case to have been acting ultra vires, in the similar sense that a company can be found to have acted ultra vires, or at least I say an individual within a company has entered the company into obligations or contracts that is beyond their authority to essentially act on behalf of the corporation, act outside of the capacity of that company. And so that's what the ultra vires doctrine refers to here. We'll get to that as we go on through this lesson. Essentially, they only can act, a company can only act within the scope of their objects clause, which is often set out in either their memorandum of association or articles of association, but will fundamentally form the company constitution. So changes brought with the Companies Act 2006 essentially has evolved the ways in which corporate capacity has operated within modern company law. This lesson is going to think about the common law approaches beginning, and then talk about the modern approaches and the ways in which the ultra vires doctrine operates today. So let's begin. Under the common law approach, or the versions which sort of predated the 2006 Companies Act, companies were limited to acting within the powers and objectives, and that the powers and objectives that a company has would be explicitly laid out and explicitly cited in their memorandum of association, okay? And if they were to have acted outside of that particular set of objectives and powers, they would be found to have acted ultra vires. This is the ultra vires doctrine. And it just essentially means that any actions taken by a company outside those specific objectives were considered to be void and unenforceable, regardless of whether or not there was a benefit to shareholders or whether it was even agreed to by the shareholders. So this ultra vires doctrine, at least from the common law approach, which has a heavy emphasis on the Memorandum of Association, was particularly restrictive, and is particularly restrictive in the sense that it means that even if a decision is taken that is outside the Memorandum of Association or outside the powers and objectives, but was at least agreed by the shareholders or was beneficial to the company, this is still seen to be an unenforceable obligation and therefore ultra vires. In a company's Memorandum of Association, there was an objects clause, and the objects clause set out the purposes for which the company was to be formed, and it set out the specific activities it was allowed to undertake through that performance. Any act which fell outside of the scope of this objects clause was considered to be beyond the powers of the company, and so they were also considered to be void, meaning that they were treated as if they had never occurred, in the first place. So, let's think about this with a couple of the issues with this, So I've already mentioned it's quite restrictive, It really does restrict their flexibility to evolve and also to adapt to new business opportunities. If I create a company in, let's say, 1993, and I have an objects and purposes clause within my Memorandum of Association, do I have to then change and alter that memorandum every single time a sort of new business opportunity arises that might step outside of the objects and purpose of that particular doctrine? That seems particularly restrictive. Does that, because generally speaking, a business will often evolve quite fluidly, with quite a sense of fluidity in relation to the ways in which new business opportunities arises, new processes for which business transactions can take place, and that can therefore mean that quite easily and quite dynamically and quite in quite a fluid kind of sense, that doctrine can essentially be rendered as restricting quite a lot of what a company seeks to do. Companies would therefore need to ensure that every new business activity fell within the terms of their objects clause. So we'd often have to have memorandum amendments quite consistently. It would also lead to situations where there was injustice for third parties, because a third party, for example, who entered into a contract with a company that was ultra vires, would and then found out later on that the company lacked the capacity to act, could lose money in that process. They could lose out on some revenue. And what would they have to do there? Would they have to sue? Would they have to try and get money out of that company themselves, which would obviously incur even more costs? So, an early important case which demonstrated the problems with the ultra vires doctrine is the 1875 case of Ashbury Railway Carriage and Iron Corporation Limited versus Ritchie. In this case specifically, the company attempted to enter into a contract to finance the construction of a new railway. The building railways was not actually, in fact, within the objects clause of the company's memorandum. And so any contract that was signed and that was made with this railway corporation, or this railway carriage corporation, was void and was ultra vires. And this obviously led to a significant injustice, given that everybody in this company wanted to construct a new railway. The people they contracted with wanted them to construct a new railway, but it was found that they could not construct a new railway because of this particular ultra vires doctrine, this quite rigid ultra vires doctrine. So, reform would come in the 2006 Companies Act. Under the Companies Act, companies are no longer required to have an objects clause in their Memorandum of Association. I believe they still can if they choose to, but they don't have to. There's no requirement anymore. If a company chooses not to include an objects clause, it will have unrestricted objects, meaning that it can essentially undertake any lawful activity within any sort of the reasonable boundaries of commercial law and contractual obligations. So, just like with the sort of model articles of association, by default, when creating a company incorporated under the Companies Act has unlimited capacity to enter into any legal transaction they so choose, unless this is explicitly limited by the Articles of Association, as you can imagine. This gives the company a certain degree of flexibility to engage in any lawful business without needing to amend their constitution, and we also have the protection for third parties as well that is also part of the Companies Act. Specifically, Section 39 of the 2006 Companies Act basically states that the capacity of a company to act cannot be challenged based on any limitation in terms of its objects. This is the case even if a company enters into a transaction beyond its objects. Let's say if the objects are specified, okay? The ultra vires doctrine that would apply there would not automatically limit the ability, essentially, for an individual to not be able to enforce a transaction fundamentally.